Suffrage as conferred by the constitutional provision is not a natural right of the citizens, but a political right intended to enable them to participate in the process of government to assure it derives its powers from the consent of the governed. Both international and domestic laws protect and guarantee its effective exercise by the people so that their sovereign will can be manifested. The people's right to suffrage is the foundation of the electoral process. The Constitution guarantees that we are a sovereign people, from where all government authority derives. Sovereignty or the power to govern is exercised directly through suffrage and direct democracy instruments, and indirectly through officials elected by the people as their public servants. The will of the people, then, is expressed in clean, orderly, and honest elections. In the Philippine electoral system, political aspirants have a certain week scheduled by the Commission on Elections to file their certificates of candidacy for the next regular elections. What happens if aspirants miss the deadline? Can they still run? Yes, as a substitute for someone else. How does substitution work? Here's what you need to know.
Substitution of Candidates, Batas Pambansa bilang 881, Section 77.
Upon death, withdrawal, or disqualification of an official candidate of a registered or accredited political party, substitution is allowed. Only a person belonging to and certified by the same political party can substitute a candidate.
Who may be a substitute candidate?
The substitute is not required to be a member of the party concerned for a certain period before he can be nominated as such. The substitute need not even be a member of a political party concerned prior to his nomination as an official candidate.
Who may not be a substitute candidate?
An independent candidate or a candidate whose certificate of candidacy has been denied due course to and/or cancelled. Sinaka versus Mula. An independent candidate may be a valid substitute provided he had previously withdrawn his certificate of candidacy as independent candidate before he filed his certificate of candidacy as a substitute. A person whose certificate was cancelled cannot be substituted. The existence of certificate of candidacy seasonably filed is a requisite sine qua non for substitution. Under Section 77, there is no mention of the case where a candidate is excluded not only by disqualification but also by denial and cancellation of his certificate of candidacy. Under the rule of expressio unius es exclusio alterius, there can be no valid substitution for the latter case. If the intent of the lawmakers were otherwise, they could have so easily and conveniently included those persons whose certificate of candidacy have been denied due course and/or cancelled under Section 77. More importantly, under the same section, not just any person but only an official candidate of a registered or accredited political party may be substituted. Cancelled certificate does not give use to a valid candidacy. Substitution is proper only when the one being substituted is disqualified, because he was considered candidate until ordered discontinued. But a candidate whose certificate of candidacy was cancelled based on misrepresentation of residence cannot be substituted, as he was not a candidate to begin with.
Section 77 requires that there be an official candidate before candidate substitution proceeds. In this regard, the certificate of candidacy is the document which formally accords upon a person the status of a candidate.
Considering that Section 77 requires that there be a candidate in order for substitution to take place, as well as the precept that a person without a valid certificate of candidacy is not considered as a candidate, it necessarily follows that if a person's certificate of candidacy had been denied due course and/or is cancelled, he cannot be validly substituted in the electoral process.
What if a candidate dies or withdraws during period to file?
There is no need to substitute as the period to file still subsists. Hence, a candidate who files for the candidate who died or withdrew files like he or she is the original candidate. Who cannot be substituted?
Aside from independent candidate who cannot be substituted because there is no party representation to be maintained or continued, a candidate whose certificate of candidacy was cancelled or denied due course likewise cannot be substituted. Hence, a candidate whose certificate of candidacy was cancelled based on misrepresentation of residence cannot be substituted because he was not a candidate to begin with.
Can a spouse substitute a candidate who dies?
Yes, during barangay election, where all candidates are considered independent owing to its non-partisan character, the spouse may substitute a candidate who dies.
In Luna versus Comelec, it was enunciated that if the Comelec cancelled a candidate's certificate of candidacy after proper proceedings, then he is no candidate at all and there can be no substitution of a person whose certificate of candidacy has been cancelled and denied due course. In the case of Miranda versus Abaya, it stipulated that Section 77 does not include those cases where the certificate of candidacy, COC, of the person to be substituted had been denied due course and cancelled under Section 78. Further, the case provides that a person without a valid COC cannot be considered a candidate in much the same way as any person who has not filed any certificate of candidacy at all cannot, by any stretch of the imagination, be a candidate at all. When may the substitute candidate file his certificate of candidacy? He may file his certificate of candidacy for the office effected not later than midday of the day of the election. What if the death, withdrawal, or disqualification occurred between the day before the election and midday of election day? He may file his certificate with any board of election inspectors in the political subdivision where he is a candidate, or, in the case of candidates to be voted for by the entire electorate of the country, with the commission. Can there be substitution at the barangay level? In the case of Relota versus Comelec, it highlighted that the absence of a specific provision governing substitution of candidates in barangay elections cannot be inferred as a prohibition against said substitution. What happens if there is a valid substitution? The official ballots shall provide spaces where the voters may write the name of the substitute candidates if they are voting for the latter. Votes casted for the substituted candidates shall be considered as stray votes, but shall not invalidate the whole ballot. If the substitute candidate has the same family name, this rule shall not apply. The case of Federico versus Comelec provides that unlike death or disqualification, withdrawal is voluntary. Generally, a candidate has sufficient time to ponder on his candidacy and to withdraw while the printing has not yet started. If a candidate withdraws after the printing, the name of the substitute candidate can no longer be accommodated in the ballot and a vote for the substitute will just be wasted. Consequently, a substitute, due to withdrawal, who files his COC beyond the deadline fixed by Comelec, shall not be considered a valid candidate. It is important that the substitute in case of withdrawal subscribe to the period fixed by Comelec as it may cause problems. One such problem is an untimely filing of the substitute for his COC may result in the candidate not being accommodated in the ballot. In the case of Francis Ong versus Comelec and the case of Romo Ong versus Comelec, it illustrated that a person without a valid certificate of candidacy cannot be considered a candidate in much the same way as any person who has not filed any certificate of candidacy at all cannot, by any stretch of the imagination, be a candidate at all. Therefore, connecting the lack of a valid certificate of candidacy, Section 77 was clear that only official candidates of a registered or accredited party may be substituted. Moreover, in the case of Fermin versus Comelec, it brings forth that a person whose certificate of candidacy has been denied due course or cancelled under Section 78 cannot be substituted because he or she was never considered a candidate. In the case of Angold versus Comelec, it stated that non-compliance with formal requirements laid down in election laws when not used as a means for fraudulent practice will be considered a harmless irregularity. Allowing the belated submission of Romualdez authority to sign certificate of nomination and acceptance or CONA will not result in the situation prescribed by Section 77 of the Omnibus Election Code, that an independent candidate will be invalidly substituted.